everyone. I'm delighted to be amongst you to facilitate the second panel of this conference. Many thanks to the BCall for the invitation and for organizing this event. This morning, we explored how systemic inequalities fit within the framework of the UNGPs. In this panel, we will take a closer look at the process of due diligence and see how it is relevant to inequalities such as those related to race, gender, LGBTQI+, and disability, caste, etc. We are joined today by Professor Barnaby Choudhury from Osgoode Hall Law School at York University, Daniel Berezovsky from Shift, Professor Erica George from the College of Law of the University of Utah, Harpreet Kaur from the UNGP Regional Bureau of Asia and the Pacific. We're also joined by Sharmika Samaradi Wakera Vijay-Sundara from Wits Law School, and by James Sinclair from FSI Worldwide. For more information on our speaker and their work, you can look at the profile following the link in the chat. Also a mention that we are also having like a live transcript of this session that you can also access through the different functionalities of Zoom. Before moving to the panel, I have two overarching comments to frame the discussion. First, and since we may not touch on all possible inequalities in this panel, a brief reminder that there are multiple facets to inequalities. Three facets are especially relevant. First, inequalities can be looked at different scales, especially within countries or between countries. Second, inequalities can be horizontal, which refers to group-based inequalities alongside gender, race, ethnicities, immigration status, ability, etc. And we will touch on a number of them in this panel. Third, inequalities can also be vertical, which refers to inequalities based on economic position. And these are usually inequalities in income or wealth between individuals or households. These different types of inequalities should be looked at holistically. And this is all the more important to do so as a number of them intersect. Echoing this, it's also worth mentioning that the SDGs adopt a crossover vision of inequalities. Indeed, several goals, as well as targets, are concerned with both vertical and horizontal inequalities and inequalities within and between countries. A second and last comment. As we discuss how to address inequalities, we should keep in mind that the ultimate goal is achieving real-world outcomes. It means several things, including having soft law and hard law frameworks that go beyond formal equality to ensure substantive equality. And it also means that these frameworks and the processes they require from businesses should translate into actual change on the ground for affected and potentially affected right holders. So these are the two crossover points I wanted to make, and which I am sure will also be reflected in the rich discussion that now awaits us. So to kick off this panel, I'd like to turn to you first, Erica. What do you see as the connection between the UNGPs framework and systemic inequalities? And what are some of the missed opportunities within this framework and the language used? And as you are answering this question, it would be particularly helpful if you could share your perspective from the three pillars of the UNGPs and explain what is the relevance of systemic inequalities for Pillar 1 on the state duty to protect, for Pillar 2 on the corporate responsibility to respect, and also for Pillar 3 on access to remedy.
Wonderful. Thank you so very much, Elsa. And I'd also like to take this opportunity. Can I be heard? Okay. I'd also like to take this opportunity to thank Lise and the organizers at the British Institute for International and Comparative Law for allowing us the opportunity to really talk deeply about the intersections of the UNGPs with inequality. I think it's a conversation we need to be having more often, and it's truly a pleasure to kick off this panel and be a part of this program. So to the question of the connection of the UNGPs to systemic equality, I think it's important to remember that these emerged from a rather modest mandate. The mandate wasn't to address inequality necessarily. It actually was quite modest. It was really being charged with looking at the impacts of globalization and business role in that. It evolved into something that's more, but not something that directly speaks on its own terms to systemic equality. So for example, I have spent time coding sustainability reports and documents, and I took the time to search for particular terms in the UNGPs. And it turns out that a word search will turn up no reference to anything that is, well, systemic appears once. And in the context of UNGP 29, which connects the discussion of operational level grievance mechanisms to framing an opportunity to have systemic problems addressed. But systemic inequality is not a part of that. Structural doesn't appear in the terms of the document. Inequality doesn't either, actually. And equality appears only once in reference to, in the preambulatory language of the principles, respect for equal protection of the laws with a sense of fundamental fairness in its application. So while undoubtedly the authors of the UNGPs appreciated that there was inequality in the world, it's less clear that that was the focused task of the work done here. That said, Pillar 1 has much to do with systemic inequality and eradicating it if we take seriously the importance of laws to protect against discrimination and to promote equality. Similarly, Pillar 2, if we're looking at the responsibility of businesses to respect, it's less clear that that's an invitation to address anything that is necessarily systemic. I will later explain that in point of fact, corporations will often participate in what is existing systemic inequalities and profit from them in many ways. And then finally, with respect to remedy, it's difficult to win cases that take on issues of systemic inequality, at least in the legal system that I operate from. It's really more focused on individual harms, the injured party, not the broader context that leads to the kinds of conditions that create sustained injury. And when I speak about systemic inequality, when I teach my students, I find it's often helpful to think about the distribution of benefits and burdens in the society and who those disproportionately fall to. And they fall to the kinds of people who are vulnerable that you've mentioned in your introduction, along lines of race or class or disability or sexual orientation. So the example I wanted to share with this group goes to a systemic problem we have in the United States, our prison system. It's a place where we find disproportionately overrepresented those people who are systemically discriminated against. So you will find disproportionately represented in our prison population, racial and ethnic minorities. You will find overrepresented people with mental illness or mental disabilities. And compounding the over-incarceration of particular populations who are vulnerable, we have abuses in our prison system. This is not something unique to the US. Many prison systems around the world have abusive conditions that violate international human rights law. But more recently, we have turned to private prisons, and the private prisons are where up to 75% of people who are detained in the United States for being undocumented, for migrating into the country, are being held. And in the private prisons, there is the profit maximization motive to have more incarceration, to have more people in custody. And there's less of an incentive to actually comply with regulations to ensure the prison conditions are consistent with international human rights norms. So I think this is a particularly interesting issue to look at through the lens of systemic inequality, because we know push and pulls of migrant flows are often the result of inequalities in a place that a person or peoples are leaving to seek a better and new life. In the United States, they'll find themselves incarcerated, and according to whistleblowers, we've had instances of women being sterilized without their consent in private prison facilities in Georgia, and we have instances of solitary confinement reported in California. I think it's important to look at the way the private sectors intersect with that. There are private prisons that are holding people, and there's human technology, data technology being used to deploy immigration raids. So facial recognition technology, Microsoft has been implicated in the use of that. Where we see gaps are in access to remedy. Just last week, there was a lawsuit filed in California on behalf of I think Mr. Carlos Morella, who was incarcerated and detained in solitary confinement for over 14 months. We don't know where these cases will go, but they're able to be brought because there's new legislation looking for accountability in incarceration. So to tie up all of these threads, I think the examples of systemic inequality would, if we took that lens to look at this, rather than this is just an isolated incident or this is border protection, integrating the UNGPs would call upon us to look at what states are doing to protect vulnerable populations, ensuring that incentives aren't set to make those populations more vulnerable for the private sector, and having a way for grievances to be aired and corrections to be made. I think I'll stop there, as I think you may have more questions.
Yeah, thank you very much, Erica. So yeah, you were mentioning the challenge and also building from your work on the detention system in the US. So I don't know if maybe you can expand a bit more on that. And I will also add, to that point, another question, which is in terms of the implementation on the UNGPs within companies. Are there some example of meaningful changes where there have been some measure of success? So it's like, I mean, two questions, if you want to elaborate more on the US present system, and also like example of meaningful change.
Okay. Meaningful change, I think things are still changing and it remains to be seen, but I was encouraged that tech companies, in particular Microsoft and Amazon and some others, once public attention got called to the way their technology was being used to be deployed for immigration raids or deployed against protesters in the last summer's Black Lives Matter protests, the company then decided that it was not going to cooperate with local police forces and with what we call ICE, the immigration enforcement coordination portion of our government, because of the way the technology was being used and their fear of complicity in what would subsequently become potential rights violations. So that was a significant shift that was reported publicly. I do not know where the company is standing presently on the use of that technology and what entities, governmental entities, they will sell it to, but that was a significant shift. I think that was in large part due to the public pressure, but the company would have had and could have had, and often reference in their sustainability report, the tools of the UNGPs. So a rethinking of what's the responsible course of conduct in this context where we've got systemic issues in being addressed. The Black Lives Matter protests were about more than just George Floyd. They were related to broad systemic problems with policing and law enforcement in our country, as well as sustained inequalities that often are burdensome more on people of color, and in particular Black people or formerly enslaved individuals who are the legacy of the United States. So those are large, significant, systemic sweeping questions that we wouldn't expect a software engineer necessarily to get into, but to have the consciousness that the products that I design may be deployed in ways that are going to be inconsistent with respect for human rights. I point to that as an example of progress. I also think meaningful change is signaled in how businesses are starting to speak about rights and social issues in their sustainability reports.
Okay, thank you very much, Erica, for sharing these points with us and also very helpful examples. Still looking at examples, I would like now to turn to James and his experience with migrant workers. So James, could you tell us a bit more about your practical experience in establishing an ethical recruitment company for migrant workers, along with the ILO and others, and especially as you saw a lot of the challenges of systemic inequalities up close.
Sure, and thanks for the question. Thanks for having me. So this is just a very practical example of some grassroots work that we've been doing. In 2006, I left a fairly comfortable life as a private practice lawyer to go and work to set up this organization, which is dedicated to trying to help migrant workers access decent work, and particularly to try to confront the problems that we now understand are called bonded labor or debt bondage and issues around forced labor. So we did it by setting up these sort of village level grassroots recruitment centers in Nepal, India, Kenya, Uganda, and then trying to help people who were working usually in the Gulf or in some cases in Iraq or Afghanistan to access work in a way that they were treated in accordance with international best practice. So what we came up against from a practical perspective was what Professor Ray Giardini rather pithily called the culture of payment expectations. And this, I think, speaks to a broader issue about how the law, as we see it, often from a global north context, intersects with the reality of life on the ground in a hard to reach, sometimes poorly governed space, sometimes and often in the global south. So we had this situation where most of the people we were talking to saw payments for jobs, whether you call them fees or bribes or whatever, as a form of job guarantee, as a way to access the market. And we still hear it today when people come to us looking for work. They often refuse to believe that we are offering fee-free recruitment. They think it's a trap or some will lead them into some sort of worse exploitation because they associate the payment of a fee with a good job. So changing that cultural norm, changing that narrative is tough. And it's taken us a long time to get to the point where we are now getting some traction. Because this question about systemic inequality is really interesting, because there is an ingrained prejudice in many societies, including the UK and the US, against what are sometimes perhaps unfairly called lower skilled workers. People sometimes even think that if you're lower skilled, then you've brought this sort of exploitation on yourself. There is often an overlap with in places like Nepal or India, with the caste system, with people being specifically discriminated against because of their racial or ethnic group. So all of these things that can be very problematic. There's also the problem, and one that we've worked on with the ILO, around discrimination against female migrant workers. There is a particularly pernicious, in my view, a set of assumptions that is made about women who migrate for work. There is, as many people know, a very sort of gendered approach to migration for work, particularly from South Asia and East Africa. So a lot of women going to work in domestic work, for example, and there is an assumption that they will have been sexually assaulted, for example, during their work. And so when they come back into what are often very conservative societies, there's a great deal of prejudice against them. So we worked with the ILO on a program in Jordan to try and help female migrant workers access protected employment in the garment sector there. And we had some success with that, but it was relatively limited because of the sort of commercial parameters that were placed around that particular project. But the challenge that we faced and that we still face today is that organizations like ours are trying to be both market maker and market supplier. And so we go out into the marketplaces and we talk to people about the benefits of what we call fair labor. So this idea of being recruited and managed in line with international norms and best practices. And we have the initial challenge, obviously, of trying to get past people's skepticism, trying to face down what is often quite entrenched attitudes, whether they be patriarchal attitudes, whether they be attitudes in the legal system or at the political level, that the current system, which enriches a lot of very sort of dodgy people, if you like, that system can and should be maintained. And it's not, of course, just in labour source countries, as they're sometimes called. It's also in labour destination countries, where you have a lot of money changing hands between people who are often quite powerful in order to be able to exploit the workers that they're bringing over. So there's a lot of overlap here, a lot of difficulty in confronting some of that. We are seeing some shifting in the attitudes of people across the spectrum. Some of that is because of the outreach work that's being done, the greater realization, understanding of the legal norms that are now developing. Some of it has been a function of technology. So a lot of the people that we recruit talk to one another on Facebook or on other platforms. And so the word gets out that actually there are other better ways of being looked after. So yeah, I guess, that's some of our experience, is that these systemic inequalities are intersectional. They are overlapping, they're changing, they're evolving and developing, sometimes in a good way, sometimes not. And it's a constant challenge.
Thank you, James. And to replace your experience and what you're describing us in relation to systemic inequalities in the context of designing mandatory human rights due diligence laws. So you've mentioned this importance of understanding the complexity at the very bottom of the supply chain, what you call the village level wonk. So could you elaborate on those challenges, and what are some ways to incorporate this into the design of smart legislation, especially at the European level and also at the global north level, where we are seeing a lot of legislative developments at the moment?
Sure, yeah. I mean, so earlier this year, I completed a PhD on exactly this subject. So I wanted to go back and sort of in the middle of my career, understand some of these issues a bit better. So I went back and researched and wrote this thesis, which very much looks at this idea of what can we do to bridge the gap between, to put it in slightly crude terms, sort of global north laws and global south realities, because there is a gap. And so I think that the starting point has to be to look at the lens from the other way around. So what impact is this law going to have on the ground? And I think sometimes we lose sight of that. I think we're getting better at it. And there are some signs, for example, the 2019 Central UK Government procurement guidance around modern slavery is quite a sensible document. It takes a balanced risk management approach to these issues. It asks its suppliers to look very specifically at certain risk factors and make sure that they're mitigating those risk factors. Obviously, we've got the EU mandatory human rights due diligence laws about to land, and again, taking quite a good sort of risk-based approach to some of that. This failure to prevent methodology that's been coming up on the rails for the last few years, and that I've been banging on about since the Bribery Act was passed, I think is a really good innovation. I think putting some pressure on businesses to understand that it's their duty not just to think in a narrow way, a sort of legalistic way about what they do within their own specific business or business group, but that actually they have to have a broader understanding of how the world works within their broader value chain, and that actually there can be repercussions on them for failing to prevent some of these abuses. The village level stuff is really important, because I mean, we often talk about something that I call the first handshake, which is, you've got to be the first person. If you want to make sure that a migrant worker is protected throughout their employment journey, you've kind of got to be the first person they meet on that journey. If you're the second or the third person, you're playing catch up. So whoever it is has got their claws into them from a bonded labor or forced labor perspective, if that's what's happened. Trying to remedy that situation down the line can be really problematic and difficult. So, being present at the grassroots level, as we try to be, is really important. But then how do you connect the laws that we're passing with the organizations who are on the ground? That's the real trick. So, there are certain things that we know don't work. Okay, short-term fly in, fly out audits of organizations, it's not working. Okay, so what can we do to try to encourage particularly companies, but all forms of organizations, to think more long-term, to think more about the relationships they're building and how to make sure they're healthy relationships within their entire stakeholder group. These are the sorts of questions we need to be asking. So you know, I don't have all of the answers, but what I can say is the sort of things like the failure to prevent methodology can I think, place the pressure that's needed. Meaningful penalties for failure, for sure, but also being honest about what, you know, companies that are trying to do the right thing. Now let's encourage them. And there's a sort of rather depressing spectacle sometimes of good companies that we know are trying to do the right thing, putting their hands up and saying, we found some problems in our supply chain. And everyone jumps up and down and says, look how terrible that is. And we've seen with some of the corporate accountability litigation that's been happening recently, the only reason why some companies are being held liable is because they made efforts to try to intervene in their supply chains. And they therefore highlighted the problems, which the lawyers were then able to say, well, in which case you knew about what was happening here, and liability was ascribed accordingly. What we really don't want is a situation to develop in which companies are incentivized to put their heads in the sand, which is why I think due diligence is the right approach, but being really sensible about what that due diligence looks like, taking a measured, risk-based approach to it, you know, applauding those companies that are trying to do the right thing, punishing those who are not doing the right thing meaningfully, but always having a view on what the bottom of the supply chain looks like and what that responds to meaningfully in a practical sense. Because if you're just designing laws in a vacuum, which I'm not saying happens, but if you're thinking about things from a sort of corporate boardroom perspective in London or in Washington, that's not what the problem is. You know, the problem is often thousands of miles away. So how do we address that? That's the critical question.
Thank you very much, James, for drawing our attention to this diversity of challenges, as well as for the practical recommendations. With these in mind, and moving forward, I would like now to turn to you, Daniel. So at Shift, you have been engaging with business around sexual orientation, gender identity, and gender expression. Can you talk about how companies need to look at the structural discrimination faced by LGBTI people when they address the way that they could be impacting the rights of people?
Yeah, absolutely. And thank you, Elsa. Thank you to the organizers for the opportunity. And like you said, at Shift, we work with companies of all sizes across all sectors and industries to help them conduct human rights due diligence, to understand how they may be impacting people's rights. And when they do, the first step of human rights due diligence, as many of you know, is to assess what rights or impacts you're connected to. And so they go across their value chain and they start thinking about severity of risk and likelihood when they try to prioritize. Severity being scale, how grave risk or impact may be, how widespread it is, and remediability, you know, how can I make it right? Or is it something that I cannot put back if it's impacted? And then they go to likelihood and they start thinking about, you know, I'm in a certain operating context, I have a certain business model, I have certain business relationships. And through severity and likelihood, they start discriminating among the issues so that they can focus on the most severe impacts that they face. The problem is that when we see that exercise time and again, we see companies looking at the risk of discrimination as if it were one of the risks that they could be impacting. And so they look at the heat map that they're putting together and they start thinking, okay, well, I have forced labor over here, child labor over here, harassment and abuse over here. Where can I place discrimination? And the problem with that approach is that discrimination and vulnerability and systemic inequality are not in and of themselves a human rights risk. They are a lens through which we need to look at all other risks. So for instance, if you think about forced labor, trade union rights, child labor, you name it, there is a way through which you can look at them depending on the lived experience of certain groups, individuals, or communities. In the case of LGBTQI people specifically, when we think about discrimination on the basis of sexual orientation, gender identity, gender expression, we need to take a step back and think about, well, how are these individuals and these communities facing the same risks or the same day-to-day work that other groups who may not be discriminated against based on SOGI. So, you know, we have to start thinking about cultural and social stigma that they face, about prejudice and assumptions. In some countries, about state-based persecution and criminalization. We have 60+ countries where acts between consensual acts between adults are criminalized, and 6 countries where people may face the death penalty. And of course, all the cultural stigma, the discrimination, the prejudice, and then the legal framework make people likelier to face abuse and violence, to have income insecurity, to rely on jobs in the informal sector rather than going and applying for a job in the formal economy, sometimes to have greater mental health needs, to have poor access to justice, and in some cases to face homelessness or face poverty disproportionately. So when we think about all these things that are connected to the vulnerability, the discrimination that some groups face, some individuals face as a company, then we can look at every right that we could be impacted and think, okay, what's the lived experience for this specific person, for this specific group? So that's the first approach that we ask companies to take, to really think about how they could be looking at different groups, different individuals across their value chain, and how they could be disproportionately impacted because they're not all starting at the same level when facing a specific risk.
Thank you, Daniel. As you talk about like the approaches companies are taking, there's another question I'd like to ask you. We see a number of companies engaging with LGBTQI rights increasingly through diversity and inclusion programs and other CSR programs. Can you provide some examples of how these issues can be integrated more into the company's human rights due diligence and with a focus on the impacts on people?
Of course, and that's a great question because, you know, since specifically 2020, Black Lives Matter, that created a great momentum across the world for more companies to be aware of the need to raise DEI in their structure and their governance. And all of a sudden, we started seeing a lot of DEI teams that started resurfacing. Companies started hiring more DEI professionals. And that's great to see. At the same time, DEI has a framework that may or may not coincide with the framework that is used by the human rights teams in certain companies. So, you know, you see a lot of great work from the DEI teams about making sure that there's a non-discrimination policy in the workplace, that there are gender-neutral restrooms for people of all genders. You start seeing that they organize pride events or events for allies to participate in pride. And if we only use that lens to think about LGBT rights, we forget to look at risks faced by LGBTI people across our value chain. And so, you know, to give you a good example, say a beer company that has, you know, a very traditional value chain, you have your raw materials that you source, then you transport them, you get them to the plant, you produce the beer, then on the other side and the downstream, you sell them, you market them, people consume the beer, and then the product, the plastics or packaging gets recycled. Across that value chain, LGBTI people are everywhere, and they face disproportionate risk that we need to account for and think about when we think about how we may be impacting them. So, for instance, if we're thinking about a processing plant where we produce our beer and we decide to change the working hours for folks, and instead of starting at 9 a.m., we say, well, we're now going to start at 7 a.m. It turns out that if you're plant is in a place where there is violence against trans women of color, which happened in Brazil, and this is a real case that a company moved their working hours just by a couple of hours, but all of a sudden, trans women of color who were at a heightened risk of going out on the street when it was still dark outside ended up being a disproportionate risk simply by going to their job every day. So that is something that you need to think about as a company, not only when you're thinking about policies, non-discrimination, restrooms, pride events, but really about how your actions and decisions may be affecting specific folks. The typical other case in that same beer example is brand promoters. Of course, brand promoters are disproportionately, it's the case of women who go to bars, nightclubs, spaces that are typically sexualized, where risk may be heightened. And if you think about harassment and abuse happening in those spaces, of course, companies need to think about ways to prevent that risk to all brand promoters. But LGBTQI people, and specifically LGBTQI people in some countries, may, on top of being exposed to harassment and abuse, not have access to the justice system, because if they call a cop to help them, or if they try to do something about a client that may be harassing them, they may end up being re-victimized by people who are there supposedly to defend them. So we need to think about that as a company. And it's so on and so forth. When we think about recycling, it's how LGBTQI people tend to be working in the informal sector. What happens if I change my recycling approach? So it's really that invitation to marry the DEI efforts with the human rights risks efforts, so that we think about risk to people, and we use a stethoscope, as we say at Shift, to assess human rights risks before we use a bullhorn to promote LGBTI risks and say we're doing great stuff in the case of LGBT rights.
Thank you, Daniel, for highlighting this difference between diversity and inclusion program and human rights due diligence, and also seeing how the two can also connect. Now taking a broader lens, and to ask you a last question, one about stakeholders. How can stakeholders play a role in the different approach that you have described in relation to LGBTQI and also maybe other vulnerable groups? And here, I would be really interesting to know more about some example of your work, and especially work that you've been doing with the International Olympic Committee and other organizations as well.
Yeah, of course. And when James said we have to bridge the gap between global North norms and global South realities, that really resonated for me, because when we talk about LGBT rights, interventions are typically designed in the global North, in the headquarter offices of companies that are working in environments where LGBTQI rights are typically more protected. LGBTQI people tend to be more openly out than in other realities. But then they use those realities to shape and design policies and programs that, when taken to the global South countries, or countries where LGBTI people may be facing risk, that doesn't necessarily work. So stakeholder engagement, to your question, is crucial when designing these interventions. At the same time, when we think about stakeholder engagement in the case of people who may not feel safe talking about their sexual orientation or gender identity, for instance, it is quite risky, because we may be putting people at risk simply by identifying them and asking them to participate in a consultation, or asking them a question, or simply collecting data. Something that we've worked with at Shift and has been useful as we work with companies is a mnemonic, and we say to companies it's important to use your brain, so BRAIN, when designing stakeholder interventions. The B is for bias. Companies tend to think about LGBT rights, and because we're bombarded typically with campaigns around love is love and same-sex marriage, they tend to think that it's a one-issue topic, and so they tend to consult with LGB folks, but not necessarily with folks who are facing gender identity or sex characteristics risks. The R being for risk, so making sure that everything that you're doing when consulting with LGBTI folks is not putting them at risk. And that may be to the question you were asking about the International Olympic Committee. When we conducted consultations with intersex athletes simply for acknowledging that they were intersex could be disqualified from participating in certain contests. So we had to make sure that we were consulting them in a way that was not exposing them to risk. I was not putting their careers at risk as well. The A being for assumptions. So for instance, I recall that a global company was conducting a survey, and they asked something like, do you feel that it's safe enough in your office to be out as an LGBTI person. And that has the assumption that everyone, when they feel safe, wants to be out at work. And there may be very good and valid reasons why people do not want to be out at work. They do not want to disclose their sexual orientation or gender identity, and not all of them have to do with safety. So making sure that you're not having assumptions about what you're trying to pursue. The I being incentives. So again, there may be design questions in which you are asking things in ways that may be putting people at risk, and so they don't feel that they have the right incentive to answer truthfully. If I think that whatever I answer is going to be seen by my boss, by my supervisor, then I may have the incentive to not disclose my sexual orientation, gender identity, or the way I am being harassed, abused, discriminated against. And finally, the N is for need. And that goes to some questions that I see in surveys and consultations time and again. Disclose, what is your gender? What is your sexual orientation? What's your gender identity? In some countries, it's part of what you have to do because of the legal framework. But more and more, companies are typically just used to asking these questions and putting it out there. And they don't realize that by collecting that information, and if that information is not collected in a way that is safe or secure, they may have information that then could be traced back to LGBTQI folks and put them at risk. So that has really helped in putting together consultations. And again, more and more, if companies go to grassroots organizations that understand the context, that understand the local situation that LGBT people are facing on the ground in specific situations, they can add to that understanding and make sure that they're informing their actions through the lens of people who are facing those risks.
Thank you, Daniel, for these insights and also the recommendation, including of companies having to think with their brain. I'd like now to give the floor to Harpreet to have a practical insights on our topic. So Harpreet, you have worked with several governments in Asia on national action plans on business and human rights. So could you elaborate on how you have brought into these conversations the importance of understanding the differential impacts and structural inequalities?
Thanks, Elsa, and the organizers for the opportunity. Through the UNDP's Business and Human Rights Asia program, we provide technical and advisory support to the governments as well as other state-based institutions on the development of national action plans on business and human rights, as well as other policy and legal framework. Currently, we are providing support to India, Indonesia, Malaysia, Vietnam, Nepal, and work closely with Pakistan and Thailand to support the NAP development processes. I think across, if one lesson that I've kind of I can share from across all the countries and all the governments that we've been engaged in developing national action plan has been is to advocate to the governments to understand the contextual realities within their own countries by conducting the baseline studies, sort of look at the differential impacts of business on the people within a country and beyond. For example, looking at, we know that how gender neutral NAPs, for example, can undermine existing state commitments to achieve gender equality. I think Erika in the beginning outlined, the NAPs are the policy tools for the implementation of the UNGPs rather than non-discrimination and equality. But it obviously has been clearly specified that the implementation of UNGPs must be gender responsive. And I think that's the kind of message that we convey to the governments, to review their rules and regulations and their policies and how they are impacting different communities, different stakeholders. At the same time, I think it's really important. One of the key aspects that a lot of governments are still not looking at is the access to remedies. So, also while they're looking at all their legislative framework, I think it's really important for the governments to keep looking at also the remedy mechanisms and look at, how they are, the differential impacts that they could have and the difference in the way, that people can access to effective remedies. So I think that's a key point that we've tried to sort of convey to the governments. At the same time, we've provided, UNDP organized a series of consultation while governments are in the process of developing the national action plans, focusing on various cross-cutting themes, including gender, environment, but at the same time, also focusing on specific populations as migrant workers, indigenous people. And I think some of the findings, some of the outputs of these consultations have really, really been crucial in terms of how the national action plans are being, being developed and framed. Because, for the NAPs, and it doesn't really stop just at the development of the National Action Plan, right? It's also about the actions that the government is planning to undertake, the implementation plans, and how they must respond to the ground realities. Similarly for the access to remedy, as I said, ensuring that affected stakeholders have an equal access to effective remedy as outlined in the UNGPs. And I think those are some of the key messages that we've been conveying to all the governments, as well as sort of looking at differential impacts. Lastly, I think the pandemic provided businesses with an opportunity to embed respect for human rights into their business values, playing an instrumental role in enhancing business resilience to future crises. Again, to build forward better sustainability, businesses must assess the impacts of COVID-19 on stakeholders, including the impact of workers within their operations and supply chains. And I think that's again been one of our key messages, to the government, to set expectations from the businesses, to set these kind of expectations from the businesses. And you would notice that, for example, the Pakistan's National Action Plan, which was recently adopted, that has a dedicated section on COVID-19 pandemic and what the businesses must do in the context of situations as COVID-19. Similarly, we've developed a human rights due diligence and rapid self-assessment on human rights due diligence in COVID-19, which is targeted at businesses so that they can consider and manage their human rights impacts. But it's something that's also been adopted and been promoted by a lot of governments that we've been working with. So I think there are different ways, to look at not just at the baseline, but also for the governments. It's really important for them to sort of start thinking about how their action matrix and how are budgets going to be spent on the National Action Plan, right? Once you've developed a National Action Plan, they need to identify the resources, both human and financial resources, and how are these resources going to be, could impact or could negatively impact different stakeholders in a way. And I think that's something that we've been sort of conveying and working closely with the governments as well. Thanks, Elsa, for the question.
Thank you, Margaret, for this insight from your experience on national action plans. I would like now to turn to another topic on which you have significant experience as well, which is like the informal sector. You've been engaging with businesses on trainings and guidance on human rights due diligence, including relating to the impacts on people in the informal economy. How do the UNGPs apply to right holders in the informal economy, and how should consideration about this informal economy be taken into account in human rights due diligence?
I think, the UNGPs apply to informal workers just like any other human beings, right? Governments should protect them from business-related human rights abuse, while companies, of course, should respect their rights. Through conducting human rights due diligence, companies can identify and address human rights risks connected to their business models as well as the informal economy, because also within their business economy, business models, informal workers appear somewhere, and I think that's something that needs to be mapped carefully. And that's how that's the only way that the potential impacts could be prevented, and actual impacts could be seized or remediated at the same time. Of course, when a company conducts human rights due diligence, it might be difficult to get a good sense of what's happening in its supply chain, especially if some of these risks materialize in the informal parts of the economy. We've recently developed a human rights due diligence facilitation guide, and what we've sort of looked at is that as a tool where the businesses can identify and map their supply chains, but then also be able to conduct human rights due diligence, even sort of looking at sort of the informal till the last year, and then in some cases it could end up at the informal workers as well. Often human rights issues in the informal economy are hidden. So if a company really wants to dig deep and understand how its business model impact informal workers and their families, I think they really would need to conduct a meaningful and ongoing human rights due diligence. And I think in this context, it should be stressed that current social auditing practices fall short of meaningful human rights due diligence. I think there was also a question in the Q&A also on human rights due diligence. And the Business and Human Rights Resource Center recently published a short paper that explains the difference between social audits and meaningful human rights due diligence. And I think some of the key messages that the paper has, are really sort of stand to the point here is that, the current social auditing processes might not be fit for purposes to uncover issues faced by informal workers. That's a key message here in the BHRRC paper as well. And while this has many reasons, I think it's really helpful to look at the differences between social audits and human rights due diligence to understand why. Again, just quoting from the BHRRC paper, I think, the way that the social audits are being still done, they're often, they can be symptomatic of lead firm approaches which rely on monitoring change or expecting things to change instead of really taking shared responsibilities. And I think to bring in the informal workers, Daniel, you were also mentioning about how, so many LGBTI people, but also if you look at women, how these are the people who are, who are already discriminated against based on their gender identities, their sexual orientation, and these are the people who are at the end of these informal economy. And looking at one example of collecting bottles, collecting plastic waste, and so many different companies are now working on sort of plastics and the waste. And even if you start sort of managing and sort of start looking at one big initiative by different companies, I think there are different ways that we can sort of take this, in a more meaningful way. Again, also, I think also what needs to be done, again, looking at the Business and Human Rights paper, is looking at the human rights and environmental due diligence required businesses to identify and assess risk and harms to people and planets, the way they are implicated in and on ongoing proactive basis. So I think what we need to look at it that these, when we're looking at informal economy, you need to you need to kind of be sure that it goes hand in hand with effective remediation for affected individuals and groups where a company has been impacted in harm, including its value chain, which in some cases, and actually in lots of, in many parts of Asia ends in the value chains, ends in informal economy.
Thank you, Alfred, and also for pointing to the recent report from the Business and Human Rights Resource Center. A last question for you. So you've and like moving on another topic. So you've also been doing very interesting work, developing a training handbook for journalists on reporting on business and human rights stories. How and I mean in what we've discussed in the conference so far, with a theme that has arisen, is the question of the role of social expectations and whether and how they are changing regarding systemic inequalities in certain contexts. So moving back to this training handbook that you have been working on, what is the role of the media and what role can they play in bringing the attention and focus on these issues of inequalities and a focus on people as well?
Sure. Thanks, Elsa. The author of the UNGP, the late John Ruggie, has played an instrumental role in progressing the business and human rights movement beyond the end of the beginning. Again, UNGPs are based on polycentric governance as a theory of change. And while UNGPs can do several things, I'll limit my answer in this context to relevant elements for journalists. I think they employ a multi-perspectival framing. This means that they try to leverage and complement three types of governance systems: state-based governance, corporate governance, and civil governance. Journalists fulfill a role which could fall under the third category, which is civil governance. Civil society actors, including journalists, they play an essential role in holding companies and governments accountable through the courts of public opinion. Moreover, the UNGPs try to address social norms, and Ruggie argued that to effectuate change progressively, we need to change the social norms, but this doesn't happen overnight. Again, here too, journalists have a really important role to play. And the fact is that whether a journalist is reporting on lifestyle, on politics, on education, on finance, there is a business and human rights story everywhere. What you're wearing, where your clothes are made, to what you're eating, looking at your supply chains to the last year, how education is being privatized and its impact on basic rights. And of course, sort of looking at, other larger issues. I mean, all of these issues have 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 a business and human rights story, and behind each of this business and human rights story is a human being. They are people, and often and I think the journalists can play a really big role in bringing these stories to the larger platform, because also they do have an ability to see the intersectional element, sort of looking at the intersectionality in the way that the people are impacted. And I think that's something that journalists can definitely contribute, and the media can definitely contribute in bringing these stories out. And we have seen how how reportage in media has really sort of has made things change. Again, this a couple of years ago, there was this big story on Thai fisheries, slavery in Thai fisheries, and the way that it has impacted lives of now positively of over 2,000 people. Similarly, what's been reported on palm oil plantations in the region. And I think there are all kinds of stories, where you can pick up and you can see how businesses have responded to, because that's where, you are able to highlight not just the reputational risk, but the associated, also the associated operational risk that the businesses are able to see. So I think that's a role that journalists can play very well. In fact, these are the trainings that we've been working. We've just launched this reporting media, the Business and Human Rights Handbook, but we would also be conducting training of trainers and training for journalists across Asia in different languages. And the handbook would be translated into different languages. So definitely a tool that's going to be made available to many, many more people. Thanks, Elsa.
Thank you, Alfred. And just a note that the link to the handbook has been posted in the chat. Very inspiring points to take away with us. So thank you very much, Alfred. And let's now move to Sharmika. Sharmika, you have spoken about the importance of looking at the longue durée of a territory and of its people to consider what systemic inequality and what due diligence should look like over the long term to address such inequality. So could you elaborate on this, and also about what might a consciousness or sensitivity to this topic look like?
Greetings. It's wonderful to be part of the conversation. So just to take a step back on the question, following from the previous session and also the contributions thus far, I think it's useful to be reminded that while we're talking about corporations and companies as institutions, as entities, we're also ultimately fundamentally talking about human actors and human beneficiaries, as well as human beings on the receiving end of the consequences of this. And I think then situating that within the context of the question, when we think about the significance of the systemic nature of inequality, or the systemic inequality, starting to look at the interconnectedness, the kind of co-constitution of both the actors themselves, the forms of oppression, and the kind of inequalities that we then find ourselves having to navigate becomes, I think, important. So the specific implications of the systemic on the inequality that we're thinking about. And here I want to kind of invite us to start thinking about, or to take a step further back, to think about the company as a concept, as an instrument in and of itself that's enabled by the law. So that's not necessarily an immutable truth, but rather is a fiction that then specifically enables this very action in the first place. So within the broader context that we're speaking about, at the core is what is fundamentally a fictional construct of the law. And I think that when we start to look at what this distinct personality facilitates, what due diligence opens the door to, is not then only a consideration of kind of structurally from the outside, the company's role outwardly, but internally, what constitutes a company? What are the legitimate parameters? And to kind of contextualize that further, I want to kind of highlight that aspect that really makes most companies as we know them, especially in the context of transnationals and multinationals, is their distinct legal personality. So the fact that they're putatively separated from what is described as their organs, whether it's their directors or shareholders. So essentially, by design, a separation from the human actors and this kind of entity that then emerges in itself. And what I want to suggest then in navigating the concept of systemic equality is how in the design itself is the potential obfuscation of the human actors that would allow for human accountability, and a kind of recognition of the consequences on human beings. So to situate that then within the idea of this longue durée and the need to look at the longue durée of systemic inequality, I'd like to kind of draw on Africa and South Africa as an example. And while it might seem somewhat abstract at first, I hope to kind of, in answering the question, kind of trace it through to the current moment. And so in this context, colonization of South Africa, for example, is often attributed, and the imposition of the Cape Colonies is attributed to the Dutch, but it was in fact actioned through the Dutch East India Company as a distinct legal person, as both a sovereign and a merchant. And so this is at the southern tip of Africa. If you go up to the north, we have a similar pattern, and this is just kind of one of several examples, but we see in the United Africa Company that was kind of made in the image of the English East India Company, that later, and this is kind of where it starts to draw into the contemporary moment, becomes the Royal Niger Company, which sells its interests in what at the time in the territory was kind of was known for enslavement of people in the trade, and then that expanded into palm oil trade, what later became the predecessor of Unilever. So what might seem like a distinct past and get cast narratively as a historical truth is actually a reality that still has very clear material and psychic consequences. So just to see, kind of tracing back or kind of jumping back to the South African context, is that there has at various points in time, through kind of various institutional interventions, but also scholars, been a recognition about this kind of systemic legacy as more than simply a kind of historical past background issue, to one that has real entrenched contextual implications. And an example of this is in the context, if we consider the Truth and Reconciliation Commission, particularly the hearings on business and labor, that held that corporations in apartheid South Africa were instrumental in the design and implementation of apartheid, but also importantly, there was this recognition that there was systemic beneficiation from the racialized, and we may add gendered structures and racialized gendered structures of society. So there's this understanding that there was this systemic beneficiation, and there's kind of a litany of examples that can be used. There was mention of kind of Shell in again, the Nigeria context as well. But what we see is clear links or conspicuous links in terms of the systemic operations of corporations and this distinct legal personality in territories, but interventions that don't really speak to both the actor in terms of individual actors, but the systemic implications of the concepts themselves and how they're utilized to actually obfuscate accountability. So almost in a circular fashion, the legitimacy of the corporation and its parameters itself have gone largely uninterrogated. So here then the takeaway point that I think may become useful in navigating that question is, you're not simply dealing with business and corporations as amoral or neutral instruments or actors, independent of context, but those that have very serious implications or are very implicated in the very structures of society. So social, economic, political relations, the very identities that we see emerging around which oppressions are structured. So in other words, to take an intersectional approach seriously in a systemic fashion necessitates looking not simply at, I think, an intersection of identities, but the dynamics of power that produce them, and particularly how the corporation as individual corporate actors, but also as an entity behind which there are human actors, kind of relates. And finally, on the question of consciousness that you speak to in the question, I think that as a starting point, including corporations' historic roles in particular contexts, again, both as individual actors that may be traceable, but also kind of systemically in terms of beneficiation, is important. And looking at how they both, and this has kind of come up thematically throughout our conversations thus far, but how they directly facilitate and contribute to existing inequality. So not assuming that they don't have a hand in or benefit from it. And how do they continue to operate in this fashion, and how a due diligence and intervention then isn't simply a question of compliance, but really a reevaluation of the entire potentially structure.
Thank you, Sharmika. You were like mentioning this idea of replacing a corporation within the structure of society. And following up on that, I would be curious to hear your view on the importance and the role of corporate structure. So insofar, we're talking about systemic inequalities, which are inherent to systems and structure. So could you elaborate a bit more on what the business relationship to inequality, and whether there are forms of business that could overcome these structural barriers?
Absolutely, thank you. So I think when looking at corporate structure, there's also an interesting, I think, in looking at the vocabulary that gets deployed and how sometimes even in kind of more progressive or critical contexts, form and substance gets abstracted, and what may seem like restructuring or kind of a critical reconsideration of structure simply becomes a reconfiguration of existing dynamics. So I suppose the first part to appreciate or to call to interrogate is questioning the structure as it relates to the substance. And I think this speaks to the systemic nature. But here then, looking then or thinking specifically about how due diligence can involve, not just must involve, sure, how the corporation interacts with external actors, but also how the corporation itself is constituted and what its legitimate parameters are. And what authorizes that in the first place. And here I think this exists both on an interpersonal level, so if we think about labor conditions and dynamics of power, but also at a structural level, if we look at some of the fundamental kernels of what becomes a definitional element of what makes a corporation, if we look at something like limited liability, for example, that in some instances, or we could argue potentially receives less attention than some of the kind of broader umbrella structural issues, but that are so clearly interrelated to the extent that if we think about limited liability of corporations, so this is essentially that veil that separates the organs of the company from the company as an independent entity. It's often described as a kind of a limitation of risk, but what it actually translates to, and many have argued this, is a displacement of liability. And the question then of where that displacement of liability goes, we can see from some of the contributions currently mentioned, is clearly onto society, onto not only those that are vulnerable, but those that are rendered vulnerable in a circular fashion. So, for example, restructuring isn't simply about, I think, reprioritizing whether profit should be a primary obligation, which of course has received attention, or whether profit should be the primary consideration of a corporation, but reevaluating something as fundamental as limited liability and the acceptable parameters for that. And recalling that at its current form, the structure of the corporation enables this, but it doesn't have to, theoretically, or it doesn't have to in a blanket sense as it currently does. So in other words, how can we reimagine the corporate structure? And to some degree, this speaks to Erica's kind of contribution also about thinking about economic relations as a whole. How could we potentially reimagine the structure such that it actually facilitates accountability instead of having to think about how to work around this otherwise constructed entity that by design obfuscates accountability. So again, this is possible not only as an external imposition, if we think about state intervention legislation and arguably that things that are already mandated by the current soft law and sometimes in kind of a national context as well. But if we think about what's also been referred to as kind of a meaningful will, if it exists to truly center the humans and human rights. The fact that the corporations themselves can be more specific about the parameters, their kind of tasks and what becomes acceptable, and write that into the design of the corporation itself, instead of allowing for the kind of ambiguity and the kind of range that then gives rise to the gray areas that allow for the kind of excesses that we see. And if I can just kind of harken back briefly to what Benita Maisveld had raised in the first session, in the South African example of CPS in the context of social grants, a kind of a clear example of kind of what again may be the abstract theory that I've been navigating so far is the fact that ultimately it becomes very clear that you have a private actor performing public services, affecting the most vulnerable members, and as Benita had mentioned, essentially, so the wealthiest and the most privileged benefiting off of further extractive behavior from the most vulnerable, those that are contextually rendered vulnerable. But what we see significantly is that that corporate entity becomes liquidated, and it's dissolved, and there's no one to go after, right? This doesn't mean that the gains kind of disappeared into the ether. It's quite clear that, again, they're human beneficiaries as much as they're very human kind of victims and survivors of those consequences. But the implications of that absence of redress, again, is not accidental, because if we think about it, if we go back to the limited liability that stems from juristic personality, we can see that structurally, even at the kind of basic corporate law 101 level, that there's scope to engage on what the implications of diligence, and particularly due diligence, in establishing risk, preempting it, and proactively kind of preventing it. So again, this is, if to be optimistic, I think an opportunity to look at due diligence as more than an intervention that gets co-opted into a box-ticking exercise, into one that calls for very serious interrogation and reimagination of kind of the corporation potentially and its justifiable parameters. So I think I'll leave it at that. Thank you.
Thank you very much, Shamika. A lot of takeaway points here, and especially as the structure of corporation and of group of companies in general is also a point that is very relevant within the context of establishing the scope of mandatory human rights due diligence in different legislation that are existing or that are currently being considered and discussed in front of different jurisdictions. So thank you so much for these points. And now I would like to turn to Barnaly, last but certainly not least. Barnaly will explain us a bit more about like the inequalities in relation to one of her many areas of expertise, international investment law. So Barnaly, how do the inequalities within the system of international investment law contribute to human rights problems?
Thanks very much, Elsa, for that great question. And thank you also to Bikkel for allowing me to be part of this really amazing discussion that we've had this morning. Sorry, for your afternoon. Now, in terms of your question, I would say that one of the main contributors to inequalities within international investment law is really the rules themselves, the legal rules that are contained within that system. Now, these rules, they contribute to the privileging of foreign investor rights over other issues, namely things like human rights issues or environmental issues. And in many ways, they also exacerbate pre-existing inequalities between developed and developing countries. Now, the principal problem with these investment rules is that they constrained governments' rights to protect human rights or environmental interests. And we already know that these things are often done to address problems of inequality. And specifically, I would say that there are two legal rules that are found in these treaties that investors have most often relied upon, that often has resulted in these investors' interests trumping other interests, particularly human rights and environmental interests. And the first is the requirement for the state to provide fair and equitable treatment. And this can mean myriad things, including things like protecting the investors' legitimate expectations that they had a right to a stable investment environment. And the second rule would probably be that a state cannot expropriate an investor's property unless there are some conditions that are fulfilled. Now, the codification of these legal rules and investment treaties ensures that property rights for investors are protected through an enforceable system involving the use of international law. But curiously, there is no similar protection through this same system of human rights or environmental rights issues. So it's probably not surprising then that when investors seek to use these legal rules and investment arbitration to protect their property rights, then there is this tendency to negate or to even diminish human rights or environmental rights that are at odds with these property rights. Now, in an earlier period, this resulted namely from investor claims for expropriation. But today, most of these issues arise from fair and equitable treatment claims. And we can actually look at a real world example that I think highlights these issues. So in Colombia, there is a region known as and I'm going to mispronounce it, my apologies, but the Páramo de Santurbán, which is a mountainous region. Now, this region is a natural and a fragile ecosystem, and it's the source of water to the local community. Now, the region is really rich in flora and fauna, and it contributes to the local community's right to a healthy environment. But the area has drawn in many mining companies due to the area's well-endowed mineral reserves. And often these mining companies have infringed on the rights of the local communities, as well as the governing efforts to protect the environment. So for this reason, the local communities have often fought to ensure that mining companies' activities in the area are limited. And they've even made proclamations or declarations that it should really be water before gold. Now, in the midst of these these communities fighting to protect the Santurbán region, there's been an investor known as Eco who brought an action against the Colombian government. And it was arguing that the regulatory measures that the government undertook to protect the Santurbán ecosystem violated the investor's right to both fair and equitable treatment, as well as constituting an expropriation. Now, we recently had the decision from the Arbitral Tribunal, and it found that the Colombian government had actually adopted these regulatory measures to protect the Santurbán ecosystem. So the regulations that the government took were actually legitimate in protecting the environment. However, good for us, I guess, that the treaty had an exemption provision which said that these types of measures that the government took could not be considered expropriations because of an explicit provision in the treaty. And so for that reason, the tribunal was unable to find that an expropriation had taken place. But the tribunal did find that there was a breach of fair and equitable treatment. And the tribunal found that the government's actions in effectively delimiting the Páramo area, that these actions were arbitrary or that they were inconsistent, and that they were effectively inconsistent with meeting the investor's legitimate expectations of a stable regulatory environment. There was, however, another provision in the treaty between Canada and Colombia. The investor was a Canadian company that provided that the legal rules for this dispute could contain a general exemption that would prevent government measures designed to protect issues like the human rights and the environment from being considered within the scope of the treaty. Yet for some reason, the tribunal found that this exception did not relieve Colombia from having to pay compensation to the investors. And the tribunal made some comments that I think are a bit suspect here, but they said that environmental protection and investor protection these issues aren't actually subservient to one another, but rather that they have to coexist in a mutually beneficial manner. And we've actually seen similar comments like this from other tribunals that in the context of human rights, where they've said effectively that human rights issues are not more important than investor protection. So in effect, we have here legal rules of investment arbitration confirming that investor protection and human rights or environmental issues, when they conflict, that often that investor rules will favor investment over these other issues. So what this means for us then is that when a government enacts a measure designed to improve issues of inequality, so for example, in relation to the protection of Indigenous rights or human rights or environmental matters, or frankly, any of the topics that the other panelists have talked about, when these kinds of issues will intersect with investment issues, we will likely be in a situation where investment rules are going to prevail and investment will win. Now, these kinds of issues become even more problematic when we talk about the disparities that already exist between developed or developing countries. And as we can see in many of these investment arbitrations, the human rights or environmental issues that are often being downplayed or negated by arbitral tribunals are those that exist already in a developing country, which are probably already countries that are struggling to improve situations of inequality. So if we combine negation of these issues with the large awards that investors, often from developed countries, can walk away with, then we can end up in a situation where a developing country is using scarce resources that could better be used to alleviate inequalities within their country, but rather they're using these resources to compensate foreign investors. And these are all consequences that are resulting from using the legal rules of an international investment arbitration. And for our attendees today, if you're interested in learning more about these issues, I would urge you to read the latest report from the UN Working Group on Business and Human Rights, which has made a similar elaboration about these issues.
Thank you very much, Bonali. And before moving to another question for you, I just wanted to remind our audience that they can post a question in the Q&A box. We may have a couple of minutes at the end to answer some of them, so don't hesitate. That being said, I wanted to follow up on the point you've just made, and especially to know if you could elaborate on the inequalities, especially in arbitration of international investment disputes and in the way in which the system is administered.
Yeah, thanks for that, Elsa. I think that that's another issue that comes up. So I've already talked about sort of what I would call the substantive issues in international investment law that are problematic and that are probably contributing to inequalities. But I would say the procedural issues within investment arbitration are equally contributing to inequality as well. And part of the reason, I guess, for this is because many of the issues that really contribute to inequality are really what I would call public interest issues. And it's a bit odd, I would say, that we are dealing with public interest issues in the context of international investment arbitration, because investment arbitration is really not a democratic system. And one would think that when one is dealing with public ideals, that it would be done within a democratic system. Okay? So I can just sort of briefly, in my very few minutes remaining, talk about some of these problems. I would say one of the first problems is that the adjudicators of these disputes are neither democratically elected or appointed by democratically elected individuals, which is what we would normally see when there is a system of adjudication. Rather, what we see is that the people that are adjudicating these disputes are private individuals whose primary qualification is usually that they've worked in the area of investment arbitration. And moreover, since there's no tenure in these positions, these adjudicators can continue to work as arbitration lawyers. So in effect, they can be what is known as double-hatted. They can work as an arbitrator on one dispute, and then they can work as a lawyer in another. So what this means is that they can be drafting their arbitral awards to align with the position that they are taking in the dispute in which they are working as a lawyer. There's also no requirement that these adjudicators have any special knowledge of general international law. Rather, their only experience is usually drawn from the private world of commercial arbitration. So what we've seen in many of the disputes is that the lens through which these arbitrators view these disputes relating particularly to issues of human rights or environmental issues is seen only through the narrow lens of private arbitration. And if you don't trust me on that conclusion, have a read of the Eco-Oro decision that I talked about above. Now, these kinds of disputes also really don't provide for much transparency. So in effect, because these decisions often implicate issues of broad public ideals, this seems to be a little at odds with a system that operates under partial or even total confidentiality. Indeed, we've seen in some cases that the final arbitral award is never even publicly released. There's also a limited role for amicus curiae, who would be the ones maybe to offer some greater public input into these disputes. So for example, in the Eco Oro decision that I referred to previously, all the amicus curiae were denied standing in the case. So this means that the local community, who probably would have been the one most affected by the dispute, had no opportunity really to offer its voice into this matter. And finally, there's no appeal available in these arbitrations. So this means, if we again go back to the Eco Oro decision, then despite the fact that there is now, I would say, pretty widespread recognition among the investment arbitration community that the tribunal's failure to respect the general exceptions provision for environmental matters might have been suspect, that there is no avenue to reconsider this issue. And at the same time, despite the fact that there isn't really any type of precedent system in the area of investment arbitration, we have seen that arbitral tribunals will consider other arbitral decisions in drawing up their judgments. So what this means is that the effectively erroneous jurisprudence from decisions like Eco Oro are destined to be repeated and relied on again. So in effect, then, we have a system of dispute resolution that's really not open to the public or to the local communities that are being affected. It's being staffed by adjudicators who may or may not have knowledge of general international law. It doesn't really offer any recourse to an appeal, and it's framed through the narrow lens of investor protection. So given these shortcomings, it's probably not surprising that this system perpetuates problems of inequality.
Thank you very much, Bonnie. I realize as we now have like just 2 minutes left that we might be too short on taking some question and also like engaging into more lengthy discussion with the different panelists. So I will just thank you here to each of our panelists for a very lively discussion, and also for our audience for joining us today. A quick note also to remind you that we will kick off the second day of the conference tomorrow with a practical panel entitled The Status Quo and the Lessons Learned on the topic of human rights, business and human rights and inequalities. So thank you very much for joining, and see you tomorrow.